Hello once again for my full semester online classes in the summer of 2019, recording Chapter 4, Civil Liberties Lecture. This is a lecture that you should be reviewing in the second week of the semester. Should be available for you by the end of the first week and the beginning of the second week. So be sure to read this chapter, and a lot of interesting information in this particular chapter. You should really be able to break this chapter down to look at the freedoms that are found in the First Amendment, what's found in the Second Amendment, and then also the rights of the criminally accused, which involves the Fourth, Fifth, Sixth, and Eighth Amendments, and then also the Ninth Amendment that focuses on the right to privacy. There are other amendments that are used in the right to privacy as well, but that's a primary amendment. So the Constitution and the amendments from the Bill of Rights are a key part in this chapter on civil liberties. A lot of information, very important to pay attention and look over that information in Chapter 4. So civil liberties are protections from improper government action. As you can see there on page 118. Are there limits to what the government can do in regulating the behavior of individuals and limiting freedoms? So here we can see the importance there of looking at civil liberties protections from government action. Now it becomes important then for people to know what rights they have and how they can deal with potential threats to them. This is a very controversial movie. It's been around for a few years, as we can see here, since 2012. It's very much worthwhile to look into, although I'm sure it would make some people angry to see this film. But you might want to read about it. You can Google this film or see clips of this film on YouTube. But it's all based on a true story that brings us back to this importance of knowing one's basic rights. So I'll just leave you with that, and you can spend your own time considering or reviewing this particular film. It's based on a real story, a real event that happened to a young lady who was put in a very unfortunate situation, and perhaps that situation could have been resolved if she had just reminded other people around her of her rights. She was accused of being a thief when she was working at McDonald's, and should have had some opportunities to say, these are my basic rights and you're taking those away from me. So she's also an individual to review and Google and find out about what happened to her and how that is associated with civil liberties. So we can look at civil liberties going back, in this case here, it's 100 years old now, during the time of World War I, which raises the important question of what rights do people have to protest a war? Is there a difference between peacetime and wartime speech? And in this case, involving the Socialist Party and passing out anti-draft leaflets and trying to weaken the effort of the United States military and the United States government in fighting World War I, is what was referred to at that time as the Great War. And this was a violation of the Espionage Act, where they protected by the First Amendment, they being the socialist. Well, the Supreme Court ruled no. Oliver Wendell Holmes, a member of the Supreme Court, wrote for the majority that the words used are used in such circumstances and are of such a nature as to create a clear and present danger. And so you perhaps come across that phrase in other situations, but certainly points out why there may be some speech that's not allowed. And there can be nonverbal speech that may also be, and of course there was some nonverbal speech in that case of Schenck versus United States. But symbolic speech, as we can see here on page 132, can be used in protest, and there's always questions on just what limits should there be on symbolic speech. And certainly the Westboro Baptist Church is brought out in many cases dealing with the issue of freedom of expression. That's also an issue, certainly in the controversial act of flag burning. When should this be allowed, and when, if ever, should it not be allowed? Is it, in some circumstances, causing a clear and present danger? This also is the issue of how do we determine that speech or press might be obscene? And you can read about that on page 135 in your text. The court case is not specifically referenced, but the outcomes of that court case are found on page 135, and this is the court case Miller v. California. And here we can see the standards that have been around now for over 40 years of determining if, in fact, something could be found to be obscene. Some work, a film, a book, a play, anything like that. So prurient means impure in thought, as you can see that from the first standard. But as we can see here, this can become a difficult standard to interpret, and certainly subject to a variety of different viewpoints. But that's why a jury would be in place to make that determination. So all of this, when we look at speech and press, is to consider the balancing doctrine, that we are balancing out two different needs here. The need or the right of the individual to express oneself versus the need to protect society. We all want to be protected in this society to some degree, but we also then want to allow individuals to express themselves. How should that be balanced out? Ongoing quest in this, the use then of the courts to make that determination. So in the Fourth Amendment, again, you can see here where those protections and protects individuals and the properties from an unreasonable search and seizure. Once again, we see a rather fuzzy word there. What exactly is unreasonable? And that's where the courts and juries can be used to make that determination. The use of the grand jury may help the defense, because the prosecution has to go through one more step to prove in a grand jury that there's sufficient evidence. But then again, it could help the prosecution because they're now moving forward with the case and get that case starting. So it is one additional step to make a determination before a trial begins. And so you can't continue to have a bite at the apple if you're the state to try to make a determination if someone is guilty. So we can see there with double jeopardy. A person has a right to be silent if they are being interviewed by the state, by police officers or other representatives of the state. An individual on trial does not have to take the stand. And we can see here also, for private property, there can be a situation in which an individual will have to relinquish that property. However, that individual will be paid by the state. And here we have the right to counsel. Now notice in the original wording of the Sixth Amendment and the original interpretation, the defendant has a right to an attorney. The interpretation has been originally that meant they didn't have a right if they could not afford one. But if they could afford an attorney, they had that right. That has since now been interpreted to mean the only way to get a fair trial is to have access to an attorney. And that comes from this case, Gideon v. Wainwright, referenced in your text. This is Clarence Gideon. He made the argument that he could not get a fair trial unless he had an attorney. And so that's a Latin term, meaning that there is going to be an appeal, that a person can make an appeal, which is what he did, without an attorney. Once the Supreme Court took the case, they also then required that he have an attorney to help him with the case. And the ruling since that time has been that people have the right, defendants have the right to an attorney if they cannot afford one. That's a big if. How do you make that determination that someone cannot afford an attorney? But that's also part of where the courts are involved to make that determination. We also see then from the Fifth Amendment the protection from self-incrimination and how that works in with Miranda rights. And you'll see this on page 143. So Miranda was questioned by the police and gave away evidence to convict him. And in that process was never read his rights, was never informed of the rights, that he did not have to answer questions. And so from that has developed the Miranda rights. And we're probably in some ways have read about that in some other situation, or we've watched it on television, someone using the Miranda rights, police officer using the Miranda rights when someone is to be a suspect. They then need to be informed of their rights and the warning, right? What you say may be used against you. Now there's ongoing interpretations of Miranda. This is one that's now close to 10 years old, but police can question a suspect 14 days after the suspect has been released from custody. So we can envision a situation where if you didn't have something like this, that every day the police could pick up an individual and see if that individual still wants to remain silent. And that could start to develop a form of harassment. But there does need to be a time in which the police can come back to a suspect and ask questions. And so the courts made a determination that 14 days would suffice of the space between one period of questioning and then the next period. So here we have the issue involving the Fourth Amendment and when evidence would not be used in trial if it was an unreasonable search and seizure. It comes from the court case Mapp v. Ohio. You can read about that on pages 139, 140. Involved this defendant, Dalry Mapp, and the question there of what to do with evidence that's gathered that's not according to a search warrant or there was not a search warrant. And so should the evidence be, as we can see, the exclusionary rule, excluded? And the determination by the courts was yes, it should be excluded. And this is a give and take of the debate on this issue between two Supreme Court justices at the time, Justice Cardozo and Justice Clark. So the criminal is to go free because the constable has blundered. Clark, the criminal goes free if he must, but it is the law that sets him free. Now, a very fair point, and we don't want to go into a lot of detail here, but just something for you to think about is what is fair to the public to allow someone to go free because there was a mistake by the police. Should there not be a consideration here of how egregious was the mistake, but how severe was the crime, how glaring was the evidence, and even if it was a mistake, this is, a very over-the-top example, but if the police didn't do a proper search, but in the process there was a dead body found in the basement of someone's home, do you just completely overlook that? And so certainly plenty of legal scholars have said you have to be reasonable about what you do when the police do make a mistake. And it still must serve the best interest of the public. And so letting a murderer, a very obvious murderer, go free is not in any way helpful to the Constitution or to the public. So there's some very important and ongoing debates and questions involving the exclusionary rule. And then we have the Eighth Amendment. As we can see here, the protection from cruel and unusual punishment. And that in itself is rather open to debate, isn't it? How do we exactly interpret that? And so when we look at cruel and unusual punishment, every time that there's been an advancement in the method of executing somebody, it was to be a more efficient and less stressful way to end somebody's life. So today we don't use the electric chair. We find it to be by and large not within the parameters of cruel and unusual punishment, and yet when it was first introduced it was supposed to be an improvement in the way people were executed. It is worth noting that when we talk about using the death penalty as a punishment, this is an organization that you may want to Google and review. It's called the Innocence Project, and many people have been exonerated, as their website will point out, that they have been people who were on trial or who were convicted in prison, and through review were found to be not guilty. And that included people on death row. For example, Greg Wilhoit. This is from Oklahoma, the state of Oklahoma. He was on death row and was very close to being executed and was ultimately found to be not guilty. So that adds to, you have the question of what is cruel and unusual. Then added to that is the issue of, can we even guarantee that the people who are being executed are in fact guilty? And so then we have this question of just what is the role of the state and how far should the state go to try to enforce laws? This is a famous quote from Ben Franklin, one of the framers of the Constitution. Those who sacrifice liberty for security deserve neither. So what are we exactly doing when we try to get tough on crime, and what does it mean then for our society and for us as individuals? Going back then to that question of the balancing doctrine. And our last area here to focus on is the right to privacy. And one of the key court cases to review here is Griswold v. Connecticut, 1965. Here we can see the amendments that are used to make this determination about the right to privacy. And in this particular case, the issue in question was birth control. And do individuals have the right, do couples have the right to purchase birth control and to use birth control? And even if at this time in 1965 you had states that had still had birth control illegal. So is this a constitutional right, the right to privacy in this case extended as a fair interpretation of the right to privacy, and does carry out for the right to birth control? And the Supreme Court ruled that it did. Going back to the Ninth Amendment, the Ninth Amendment is oftentimes interpreted as the amendment that gives people rights that are not specifically mentioned in the Constitution. Does every right that we have to be specifically mentioned in the Constitution? And if you've been reading through chapters 2 and 3 and 4, you get the sense, especially in chapter 2, that the United States Constitution, compared to many constitutions, is a very brief document. There's a lot of benefits to having a brief document, but it does mean that it has to be subject to interpretation. And so the Ninth Amendment is included to say Just because it's not written in the Constitution does not then mean that a person does not have that right. So every time someone is to enjoy a particular right, it does not have to then be determined that there needs to be an amendment. I mean, some things we can perhaps take for granted, the right to eat, the right to breathe, but does it also mean that we have the right to do things that we see here on this chart, to teach a child a foreign language? Now, it would be foreign to other people. It's certainly native here in North America, but that could be, certainly it was brought out in the issue of Native American languages, that do children have a right to learn those, even though it's not in the Constitution? And yes, under the Ninth Amendment, that's a right that people can enjoy. People have a right to send their children to private schools. Again, Ninth Amendment. To procreate, very interesting case. Does the state then have a right to make a determination that people don't have an IQ level adequate enough for them to reproduce? And the courts have said that's not what the state has a right to do and to limit. And so the Ninth Amendment is extended for those protections. And the right then to travel to another country. Does there have to be an amendment that says that? No, the Ninth Amendment covers that. That is a right that people should expect to be able to have. And so you'll see here at the end of your text that the Ninth Amendment and the right to privacy, with bringing in other amendments, covers other areas that we would consider to be part of a person's private decisions. And it's not as if this has been entirely resolved, but these questions have been by and large addressed to have some uniformity across the country. There's still bringing in Chapter 3 and federalism, that is certainly still a big issue in some areas with abortion, even more so on the right to die, not so much for same-sex couples. But clearly there are some differences among the states on when someone or how someone can make a decision on ending his or her own life. And the state of Oregon is one of the leading states on that issue, as you'll see in this discussion here. This is a very powerful area for sure, and it's worth your time to look this over and consider, what does the right to privacy mean? It's probably one of the key areas that we see some major debates in our society. So we'll stop there, and then we'll be moving on to Chapter 5 on civil rights.